Officer, for a brake light violation, you don't have authority to order me out of the vehicle unless you have reasonable suspicion of another crime.
Excuse me? I'm giving you a lawful order.
A broken brake light is an equipment violation. MIMS allows you to order me out, but not without a reasonable cause. What's your justification?
My justification is that I'm a police officer and you need to do what I...
Civil rights attorney Karen Washington was driving southbound on Interstate 85 at 2:20 in the afternoon on a Monday in June when she saw flashing lights in her rearview mirror. She was 43 years old, a senior partner at a law firm specializing in police misconduct and civil rights cases, and had spent the last 15 years of her career suing police departments for constitutional violations. Karen wore a professional blue blouse and was returning from a deposition in a neighboring city. Her dashboard showed she was driving 68 miles per hour in a 70 zone, well within the legal limit. She had no idea why she was being stopped, but her professional experience immediately put her on alert. She verified her dashcam was recording, then grabbed her cell phone and positioned it in the mount where it could also capture the interaction. Karen signaled and pulled onto the highway's wide shoulder, stopping her blue Honda Accord safely away from the traffic lane. She placed both hands on the steering wheel where they were clearly visible and waited. The patrol car stopped behind her, and she watched in the mirror as an officer got out. He was a white man, appeared to be in his early 30s, with a stocky build and mirrored sunglasses that hid his eyes. His badge, which Karen noted when he approached her window, identified him as Deputy M. Richardson of the county sheriff's office. Richardson walked to the driver's window with his hand resting casually near his weapon, a posture Karen recognized as standard intimidation tactic even during routine stops. Karen lowered her window when Richardson reached the side of the car. Before she could say anything, Richardson said he had stopped her for following too closely to the vehicle ahead. Karen was genuinely confused. She had been maintaining at least 4 car lengths from the traffic ahead, more than the safe distance required by state law. She said politely she didn't think she'd been following too closely, that she had maintained appropriate distance. Richardson said he determines what appropriate distance is, and that she'd been too close. Karen felt the familiar sense of an encounter being conducted based on something beyond legitimate traffic safety concerns. She asked if Richardson could specify exactly how close she had been and to which vehicle. Richardson said he didn't have to justify his observations, that he was a trained officer and his assessments of traffic violations were sufficient. He asked for her driver's license, registration, and proof of insurance. Karen said she would provide those documents, but first would like to understand the specific basis for the stop, as it was her right under the Fourth Amendment to have reasonable probable cause articulated for detention. Richardson removed his sunglasses and looked at Karen with an expression that mixed irritation and something darker. He said she wasn't going to start with legal talk, that if she didn't provide her documents immediately she would be obstructing. Karen kept her voice calm but firm. She said she wasn't obstructing, she was exercising her constitutional rights by asking a legitimate question about the legal basis for the stop. Richardson then said something that would be replayed millions of times and cited in countless legal articles and news reports. He said, "I don't care about the Constitution. I don't care about your rights. You're going to give me your documents now, or you're going to be arrested for obstruction." Karen felt a combination of shock and recognition. Shock because a law enforcement officer had just explicitly stated he didn't care about the Constitution he had sworn to uphold. Recognition because this was exactly the type of attitude she had spent her career fighting, but rarely captured so clearly on recording. She responded calmly that he had just said he didn't care about the Constitution, that that statement was being recorded, and that as a law enforcement officer, he had taken an oath to uphold that Constitution. Richardson noticed Karen's dashcam and her phone recording. He said she didn't have permission to record him, that it was illegal. Karen, an attorney who had litigated dozens of cases involving this exact issue, informed him that citizens had an absolute right to record police officers performing their duties in public spaces, that this right had been confirmed by multiple federal court decisions, including binding circuit decisions, and that any attempt to prevent her from recording would be an additional violation of her First Amendment rights beyond the Fourth Amendment violation, occurring through the stop without cause. Richardson said he didn't care about court decisions, that in his jurisdiction he made the rules. Karen said he was profoundly mistaken, and that she strongly recommended he contact his supervisor before proceeding. Richardson ordered Karen to exit the vehicle. Karen asked under what legal authority he was ordering her to exit. Richardson said he didn't have to provide legal authority, that he was an officer and she had to obey his commands. Karen calmly explained that officers had to have articulable reasonable suspicion of criminal activity or safety concern to order a driver to exit a vehicle during routine traffic stop. That under Pennsylvania versus Mims and Maryland versus Wilson, officers could order drivers and passengers to exit vehicles, but that power had to be exercised reasonably and not arbitrarily. That she had cooperated by providing opportunity for him to articulate probable cause, and that she would provide requested documents, but that she had a right to understand the legal basis for commands being given. Richardson reached for the door handle and tried to open it. The door was locked. He ordered Karen to unlock it. Karen said she wasn't going to do that without understanding why he was escalating a routine traffic stop to ordering vehicle exit. Richardson said she was being impossible to work with, that her behavior was suspicious, and that the more she argued, the more convinced he became she was hiding something. Karen pointed out she wasn't arguing. She was asking legitimate questions about her rights, and that exercising constitutional rights wasn't legal basis for suspicion of criminal activity. She said she was an attorney specializing in constitutional law and that every word of this interaction was being documented on 2 separate cameras. Richardson became visibly more irritated when Karen identified herself as an attorney. He said he didn't care if she was an attorney, judge, or president, that she was in his jurisdiction, and he determined how law enforcement was conducted. Karen said he was fundamentally misunderstanding how law enforcement worked in a democratic country under rule of law, that he had no personal authority to ignore constitutional rights, that every action he took had to be justified under established legal framework, and that his statement that he didn't care about the Constitution or her rights was not just professionally inappropriate, but potentially basis for personal and departmental liability. Richardson called for backup over the radio. Karen heard him saying he had an uncooperative driver refusing to exit vehicle, behaving suspiciously, and potentially under the influence. Karen immediately spoke loudly for the cameras that she was not under the influence of any substance, that she was completely sober, and that Richardson's characterization of her behavior as uncooperative was false, that she had offered to provide documents but had asked legitimate questions about legal basis for the stop first. Richardson told her to stop talking or she would be charged with obstruction. Karen said she had a First Amendment right to speak and that threats of false charges to silence her were an additional form of rights violation. A second patrol car arrived 6 minutes later. An older deputy got out, looked at the scene, and immediately seemed to recognize something was wrong. He approached Richardson, and they talked briefly away from Karen's car, but both her dashcam and phone captured parts of the conversation. The older deputy, whose badge said Sergeant Phillips, asked why Richardson had stopped the vehicle. Richardson said following too closely. Phillips asked if Richardson had dashcam showing this. Richardson said no, that it was his judgment. Phillips asked why the driver hadn't exited the vehicle when ordered. Richardson said she was being difficult, claiming to know her rights. Phillips looked through the window at Karen and asked if she had provided identification. Richardson admitted she hadn't, that she had insisted on discussing the legal basis for the stop first. Phillips walked to Karen's window. He introduced himself and said he understood there was some confusion. Karen responded there was no confusion on her part, that she perfectly understood her rights, and that Deputy Richardson had conducted the stop in a manner that violated multiple constitutional protections, that he had stopped her without articulable probable cause, had explicitly stated he didn't care about the Constitution or her rights, had attempted to prevent her from exercising her First Amendment rights to record, and had made false characterizations of her behavior when calling for backup. Phillips listened, his face growing increasingly concerned. He asked if Karen was an attorney. Karen said yes, she was a senior partner at a civil rights firm specializing in police misconduct. Phillips visibly paled. Phillips asked Karen for her documents. Karen said she would provide documents now that a supervisor was present, but that she wanted to note for the record she had offered to provide them from the beginning after asking a legitimate question about basis for the stop. She handed her driver's license, vehicle registration, and proof of insurance through the window. Phillips examined them, then verified them over the radio. Everything was in order, no warrants, no registration issues. He returned and handed Karen's documents back. He said she was free to go, that he was sorry for the confusion. Karen said she wasn't just going to drive away, that she wanted Richardson's full name and badge number, that she wanted the incident number for this stop, and that she would be filing a formal complaint. Phillips provided the requested information. He tried again to apologize, saying sometimes communication broke down during traffic stops. Karen said this wasn't communication breakdown, that Richardson had explicitly stated he didn't care about the Constitution or her rights, had attempted to prevent her from exercising First Amendment rights, had stopped her without articulable probable cause, and had made false characterizations when calling for backup. That each of those actions was a separate violation, and that she wasn't going to let it slide simply because a supervisor arrived and tried to de-escalate. Phillips said he understood her concerns and that she had a right to file a complaint. Karen said she was going beyond complaint, that she was going to personally sue Richardson in the sheriff's office under Section 1983 for civil rights violations. Richardson, who had been standing by his patrol car, heard that and walked back. He said Karen was threatening a law enforcement officer, that was a crime. Karen almost laughed at the absurdity. She explained that informing an officer you intend to pursue legal remedies through appropriate court system wasn't a threat, it was exercise of legal rights. That threat implied intention to do unlawful harm, while lawsuit was exactly the legal mechanism provided by the system to address rights violations. That if Richardson didn't understand that basic distinction, he had no business carrying a badge and weapon. Richardson said he wasn't going to be talked to like that by some fancy lawyer who thought she was better than law enforcement. Karen said she didn't think she was better than law enforcement. She respected appropriate law enforcement, but that she absolutely thought she was better than a specific officer who had just declared he didn't care about the Constitution. Phillips intervened and told Richardson to return to his patrol car. Richardson protested, but Phillips repeated the order more firmly. Richardson finally backed away, but not before telling Karen he would remember her, that she wouldn't want to drive in his county again. Karen said that sounded like a threat of harassment and retaliation, and that she would certainly add that to the list of violations in her lawsuit. After Richardson returned to his patrol car, Phillips tried once more to calm the situation. He said Richardson was a relatively new officer, that sometimes young officers were overly zealous, and that the department took training seriously. Karen said this clearly went beyond excessive zeal to complete disregard for constitutional rights. Phillips asked if Karen would be willing to come to the sheriff's office and discuss what had happened with supervisors, that maybe they could resolve this internally. Karen said no, that this had gone beyond internal resolution, that she had spent her career suing departments for exactly this type of conduct, and that when an officer explicitly stated he didn't care about the Constitution while violating multiple rights and recorded himself doing it, that required formal legal accountability. That she would file a complaint with the department as a matter of record, but that she was also filing a federal lawsuit. Phillips nodded, looking defeated. He said he understood and that he was sorry it had come to this. Karen said she was sorry too, but that accountability was the only way real change happened. Karen drove away 23 minutes after being initially stopped. She immediately called her office while driving, using Bluetooth to remain hands-free. She spoke with her partner James Martinez and described what had just happened. James listened with growing disbelief and then began laughing not because it was funny, but because an officer had literally handed them a textbook case of constitutional violations while recording himself doing it. He said they had to ensure preservation of both recordings immediately, that those recordings were gold in terms of evidence. Karen said she had already started uploading the phone footage to cloud storage, and that she was going to stop at a service station to back up the dash cam as well. Karen arrived at the office an hour later and immediately gathered her team. She, James, and 2 associate attorneys reviewed both recordings multiple times, documenting each statement, each violation. The recordings were extraordinarily clear. Richardson's statement, "I don't care about the Constitution, I don't care about your rights," was perfectly captured. His attempt to prohibit recording despite established case law. His lack of articulable probable cause for the stop. His false characterization when calling for backup. And his final threat of retaliation. James said in 15 years practicing civil rights law, he had never seen an officer so explicitly declare disregard for the Constitution while being recorded. It was as if Richardson had read a manual of constitutional violations and decided to commit everyone. The firm began building the case immediately. They filed a formal complaint with the sheriff's office as required before federal litigation, detailing each violation and including timestamps from the recordings. They also sent a formal letter to the sheriff alerting him that federal lawsuit would be filed and that all evidence must be preserved, including any body camera or dash cam recordings Richardson or Phillips might have, dispatch records, and any training policies related to constitutional rights and traffic stops. The letter was strategically designed to create a record of proper notice and prevent any future claim the department hadn't been warned to preserve evidence. The story leaked to media within 2 days. One of the associates had mentioned the case to a journalist friend, and the reporter immediately recognized the news significance. Officer declaring he didn't care about the Constitution while violating the rights of a civil rights attorney who specialized in suing police for constitutional violations, all captured on video. It was a story that practically wrote itself. The local news station contacted Karen requesting an interview. She initially declined, not wanting to prejudice pending litigation. But James argued that making this public could actually strengthen the case by creating pressure for reform and demonstrating broader pattern if others came forward with similar experiences with Richardson. Karen agreed to a limited interview. She appeared on the evening news, professional and measured in her comments. She described being stopped without clear cause, asking for articulation of probable cause, and then hearing an officer declare he didn't care about the Constitution or her rights. She said that as an attorney who had dedicated her career to civil rights, she knew exactly how serious those statements were, that the oath every law enforcement officer takes is to uphold the Constitution, and that when an officer explicitly rejects that oath, it's not just individual failure, but symptom of deeper training and supervision problem. The station played portions of the recordings, with Richardson's face blurred but his voice clear. The impact was immediate. The video went viral within hours. People were shocked and furious. Comments flooded social media discussing how an officer could so openly declare disregard for the Constitution. Civil rights organizations shared the video with statements condemning not just Richardson, but the law enforcement culture that allowed such attitudes to develop. The sheriff's office issued a statement saying they took allegations seriously, that an investigation was underway, and that they expected all officers to uphold the highest standards of professionalism and constitutional respect. But the statement was met with skepticism as other people began coming forward on social media sharing their own negative experiences with Richardson. 3 people contacted Karen's firm within a week, all describing stops by Richardson that involved what they felt was harassment and unnecessary escalation. A black man described being stopped for alleged failure to signal, but when he questioned whether his signal lights were functioning, Richardson had ordered him out of the vehicle and conducted an extensive search without articulating reason. A Latina woman described being stopped for erratic driving she insisted hadn't occurred, and when she asked for dashcams showing erratic driving, Richardson had threatened to arrest her for obstruction. An older white man described being stopped for speeding when his speedometer showed him within the limit, and when he politely disagreed with Richardson's assessment, he was threatened with contempt citation. A pattern was emerging of an officer who didn't tolerate questioning and escalated encounters unnecessarily. Karen filed the federal lawsuit 3 weeks after the incident. The lawsuit named Deputy Richardson personally and the county sheriff's office. The allegations were extensive and devastating. Violation of Fourth Amendment rights through stop without reasonable probable cause. Violation of First Amendment rights through attempt to prohibit legally protected recording. Intentional infliction of emotional distress, harassment, and retaliation. And, critically, the lawsuit argued Richardson's explicit statement that he didn't care about the Constitution demonstrated a pattern of disregard for constitutional rights that was indicative of departmental training and supervision failure. The lawsuit sought $2 million in damages, but, more importantly, sought comprehensive policy reforms and declaratory judgment establishing that Richardson's statements and actions constituted clear violations. The complaint included complete transcripts of both recordings, frame-by-frame analysis of key moments, and extensive citations of established case law on First and Fourth Amendment rights. It also included statements from the three other individuals who had experienced problematic encounters with Richardson, establishing a pattern of conduct rather than isolated incident. James had drafted the legal sections with surgical precision, each allegation supported by specific precedent, each violation linked to established constitutional doctrine. It was an 84-page document that read as both legal indictment and educational treatise on why these protections existed. The sheriff's office tried to settle immediately. Their lawyers knew they had a catastrophically bad case. Officer recorded declaring he didn't care about the Constitution. Experienced civil rights attorney who had meticulously documented everything. Multiple additional witnesses establishing pattern. Massive media attention, overwhelming public sympathy for Karen. The initial offer was $150,000. Karen rejected it without hesitation. This wasn't about money. It was about establishing there were serious consequences when officers explicitly rejected their constitutional oaths and about forcing changes that would protect future motorists from similar treatment. Negotiations continued for months while internal investigation proceeded. Internal Affairs investigation concluded Richardson had violated multiple departmental policies. He had failed to articulate adequate probable cause for the stop. He had made professionally inappropriate statements about the Constitution. He had attempted to prohibit legally protected activity, recording. He had made false characterizations when calling for backup, and he had threatened retaliation. The recommendation was termination. Richardson contested through the police union, arguing he was being scapegoated, that he had made a good faith stop, and that his statements had been misinterpreted. But the recordings made his defenses impossible to sustain. The arbitration hearing was open to the public. Karen attended and testified, calmly and professionally describing the encounter. When Richardson's attorney tried to suggest she had been combative or uncooperative, she pointed to recordings showing her calmly asking legitimate legal questions and offering to provide documentation. When the attorney tried to argue Richardson's stop had been based on legitimate traffic violation, Karen's traffic safety experts testified that following distance shown in recording was well within safe and legal parameters. When the attorney tried to minimize Richardson's Constitution statement as frustrated exaggeration, Karen's legal experts explained that such statement from law enforcement officer wasn't harmless exaggeration, but indication of fundamental lack of understanding or respect for constitutional duties. The arbitrator upheld the termination. The written decision was remarkable in its candor. It pointed out that law enforcement officers took an oath to uphold the Constitution, that oath wasn't empty formality, but fundamental commitment of the profession. That Richardson's statement he didn't care about the Constitution was explicit rejection of that oath, that his actions during the stop had consistently violated both departmental policy and constitutional rights, and that his threat of retaliation demonstrated fundamental bad faith that was incompatible with appropriate law enforcement. The decision concluded termination was not just appropriate, but necessary to maintain integrity of law enforcement. With Richardson's termination confirmed, settlement negotiations accelerated. The city increased the offer to $400,000. Karen counter-offered $1,200,000 with specific policy reforms. Negotiations finally settled at $875,000, with Richardson personally liable for $50,000 through wage garnishments from any future employment and sale of personal assets. But the monetary component was only part of the settlement. The policy reforms were where Karen had focused her energy because those changes would benefit all future county citizens. The settlement required every officer to complete 60 hours of mandatory training annually on constitutional rights, specifically focusing on First and Fourth Amendment rights during traffic stops. The training had to be conducted by outside instructors with expertise in constitutional law, not just internal departmental trainers. Each officer had to pass written assessment demonstrating understanding of when they could and couldn't stop vehicles, when they could and couldn't order drivers to exit, and citizens' absolute rights to record officers performing public duties. Failure to pass assessment would result in additional training and suspension from duty until competency was demonstrated. The settlement also established mandatory verification protocol for all traffic stops. Officers had to articulate specific probable cause to dispatch before initiating stop. That articulation would be recorded and reviewable. If driver questioned basis for stop, officer had to provide specific explanation, not just generic reference to traffic violation. And if driver identified themselves as attorney, judge, or other court or law enforcement officer, supervisor had to be notified immediately to ensure stop was conducted appropriately. This last requirement was particularly important because it recognized that while all citizens should receive appropriate treatment, those with specialized legal knowledge were more likely to recognize and challenge violations. A civilian oversight panel was created, composed of 5 community members, including at least one attorney with civil rights expertise. This panel would have access to all body camera and dash cam recordings of traffic stops, with power to review stops randomly and any stop where complaint was filed. The panel could recommend discipline, additional training, or policy changes. While recommendations weren't automatically binding, the sheriff had to respond publicly in writing to each recommendation, either implementing it or specifically explaining why not. This transparency was crucial for accountability. Karen donated her portion of the settlement, minus legal costs, to establish a constitutional rights education fund that would provide free educational materials for county residents about their rights during police encounters. The fund created brochures, videos, and community workshops, teaching people how to properly document stops, what questions they could ask when they had to provide identification versus when they didn't, and how to file complaints if they felt their rights had been violated. James led development of these materials, ensuring they were legally accurate but accessible to people without legal training. The case, Karen Washington versus Richardson and County, became one of the most widely cited civil rights cases involving explicit officer statements about the Constitution. Law schools used it in courses on Section 1983 litigation and First and Fourth Amendment rights. Police academies used it as the definitive example of what not to do, showing the recordings in training programs across the country. Richardson's statement, "I don't care about the Constitution," became shorthand in civil rights communities for the type of attitude that fueled police misconduct. Advocacy organizations used it in training materials, demonstrating why documentation through recording was so crucial. Richardson disappeared from law enforcement permanently. His certification was revoked by the State Peace Officer Standards Commission after reviewing the recording and arbitration findings. He tried to find work in private security, but the viral video of him declaring he didn't care about the Constitution followed him. Employers doing basic background research found the story immediately. He ended up working a series of retail and warehouse jobs, a percentage of each paycheck garnished to pay his debt to Karen. Some acquaintances expressed sympathy, saying one moment's statement had ruined his life. But others pointed out it wasn't an isolated statement, but revelation of underlying attitudes that informed how he conducted law enforcement. Sergeant Phillips, who had responded as backup, faced 2-week suspension without pay for not intervening more decisively when it became clear Richardson was violating policy and rights. Investigation concluded that while Phillips had eventually de-escalated the situation, he should have recognized violations earlier and taken control of the scene more assertively. Phillips accepted suspension without contesting and completed additional supervisory training. He remained with the department, but was frequently used in training sessions to discuss supervisors' responsibilities during stops that were going wrong. The sheriff's office implemented all policy reforms within 6 months. New training began immediately with 60-hour intensive initial session for all current officers, followed by annual renewal requirements. Training was conducted by constitutional law professors from nearby university in partnership with civil rights attorneys, including James from Karen's firm. Officers initially resisted what they perceived as excessive training, but as they worked through the materials, many admitted their prior academy training had been inadequate in preparing them for complex constitutional issues that arose during routine stops. The Civilian Oversight Panel began reviewing recordings and issuing quarterly reports. The first report identified 3 additional officers who had patterns of questionable stops or problematic interactions with drivers who asked about rights. 2 were placed in additional training and close monitoring. 1 was terminated after review revealed he had lied in reports about multiple stops. The panel publicized its findings, creating transparency the department had never had before. Residents began paying attention, knowing there was now real oversight mechanism beyond just filing complaint that could be ignored internally. Years after the incident, when interviewers asked Karen about the case, she always emphasized the same points: that she had been fortunate to have knowledge, resources, and cameras recording to capture what happened, that countless other drivers faced similar violations without those advantages, that Richardson's statement about not caring about the Constitution was shocking in its honesty, but probably reflected attitudes many officers held but weren't foolish enough to verbalize, and that real change required not just punishing individual bad officers, but reforming training, supervision, and accountability systems that allowed bad behavior to flourish. Karen continued her civil rights practice, now frequently referencing her own case when explaining to clients what proper documentation looked like and why it was so crucial. She gave talks at law schools, community events, and civil rights conferences about the case. She always ended with the same point: the Constitution wasn't an abstract document or theoretical ideal. It was a set of practical protections that applied every day, in every traffic stop, in every encounter with governmental authority. And when officers declared they didn't care about it, they weren't just violating departmental policy. They were rejecting the fundamental foundation of American democracy under rule of law. The video of the stop remained online, viewed millions of times, shared in countless training programs and classrooms. It captured a moment where everything abstract about constitutional rights became concrete. An attorney calmly citing case law while an officer explicitly rejected the Constitution's relevance. 2 cameras capturing every word, every expression, every moment of an encounter that could have escalated to arrest or worse if Karen hadn't known her rights so completely. And eventually, it captured the triumph of accountability over impunity, of reform over status quo. The $825,000 total settlement had sent a clear message. Declaring you don't care about the Constitution while wearing a badge and gun wasn't acceptable exaggeration or forgivable moment of frustration. It was disqualifying for law enforcement. The policy reforms had created structures that would make it harder for future officers with similar attitudes to operate without detection. And the legal precedent had established that explicit statements of disregard for constitutional rights, especially when combined with actual violations of those rights, constituted solid basis for both personal and departmental accountability. For Karen, that Monday afternoon in June when she was stopped without probable cause had transformed from professional frustration into defining case that would impact law enforcement beyond one county. Richardson had thought he was just dealing with a difficult driver. He didn't realize until too late he was dealing with an attorney who had dedicated her career to holding officers accountable for exactly the type of conduct he was demonstrating. Her cameras had captured everything. Her knowledge of case law had guided every response. Her professional calm had prevented physical escalation, and her determination to pursue accountability had forced changes that would benefit countless future drivers who would never know their names. The stop, that should have lasted 3 minutes and ended with simple warning or citation, instead lasted 23 minutes and ended with an officer losing his career, a county paying nearly $1 million, and policy reforms that would fundamentally change how law enforcement was conducted. All because one officer had made the fateful choice to declare he didn't care about the Constitution to a woman who had spent 15 years proving the Constitution absolutely mattered and that there were consequences when those with governmental power decided it didn't. The recordings proved she was right. The reforms ensured future generations of drivers would have at least some additional protections, and the legal precedent established that even when an officer says he doesn't care about the Constitution, the legal system still does and still can force accountability.